Good day, students. You are welcome to Scholars Universal Secondary School. This is government class, and the topic we are going to consider today is the judiciary. The topic is the judiciary. But before we go into our discussion for today, let us quickly talk about our previous lesson. Don't forget that in the past 3 weeks, we started to look at the structure and the organs of government, the structure and the organization of government. And there we started from the legislature arm of government. Then we talked about the bills. Then in our last class, we talked about the executive arm of government. And don't forget that in the executive arm of government, we look at the meaning, the types, the functions as well. So therefore, in the meaning, we talked about the executive arm of government as the arm of government that is saddled with responsibility of formulating policies, rules and regulations, execution and enforcement of law in the country. So, and we look at the various levels of government at which we have executive arm of government. We look at the federal level where we have executive comprised of the president and his ministers. Then at the state level, we look at the governor of a state and his commissioners, and at the local level, we talked about the chairman of the local government and the councillors and other supervisors for each of the departments in the local government. So therefore, we move further again to look at the types of executive. We don't forget. So we mentioned 5 types of executive. You could remember that vividly. So we started with the parliamentary executive, where the executive real powers are vested in the executive, in the prime minister, in the executive arm of government, as the executive arm of government in the parliamentary or cabinet system of government rather. Then we talk about the presidential executive, where we say the real executive power is vested in the head of state, the president, who happen to be the head of state and the head of government. So then we talk about single executive, where the only head of government is superior and vested with the real executive power, while others in the cabinet are subordinates to him. Then we talk about the titular executive, where we say that it only represents the emblem or a symbol of a state, and such performed what we call ceremonial functions. Then don't forget that of collegial executive as well, where all the executive members were seen as equal in the cabinet. So no superior and no subordinate. So they are all equal in whatever decision to be made, seen as equal. And we talk about the function as well. So we look at the function. One of them is that the executive arm of government formulates policies, rules and regulations, and enforce law. Then the executive appoints ministers, judges into various offices or departments. Then he gave prerogative pardon to those who have convicted of criminal offences that are in the prison, custody, or which we now call the correction houses or correctional centers today. So that's how much we can go on our last lesson to remind ourselves. But today, let's talk about judiciary in detail. So now look at the picture we can see here. See, this picture is showing us the pictures of the judges, the lawyers here. And when we talk about judiciary, we are talking about the judges, the lawyers, the constitution, the courts. So all these are elements of judiciary. So this picture is actually showing us one of the elements of the judiciary that we are to consider for today. Then let's go to the meaning of judiciary. So when we say judiciary, from our revision so far, we discover that it is the third arm of government as we have it in our note here. The judiciary is the third arm of the government. So as the third arm of the government, it is responsible for the interpretation of laws, trials and cases involving individuals, organizations and the states. Now when we say interpretation here, that is, the judiciary is the one that explains the content of the laws to the people, and when it is time to try anybody who has acted against the provisions of the constitution, they explain the content of the constitution or the content of the law to really convince that person of his offences and how guilty he is before the court of law. Then they try to explain the content of the provisions of the constitution to individuals and organizations so that we can be conscious of the provisions of the constitution so that we will not be victim of the law. Then the judiciary is made up of the magistrates, judges and chief judges who preside over such courts as the customary magistrate, high courts, court of appeal and supreme court. Now what we are trying to say here is that when we talk about judiciary, we are talking about the apart from the judges we have seen above, we are talking about the courts. And when we talk about the courts, the judges, we have them in various forms of the courts which we have in the country. So we have the magistrate courts, where we see the magistrates trying to adjudicate and administer justice. So we have magistrate courts at the local levels. Then the magistrates are there to administer justice as it is supposed to be done in the court. Then we have the high courts, which you can find at the state level, where we have judges as well that are there to administer the justice on every cases before the court. Then we have the court of appeal as well. Anyone that is not satisfied with the judgment of the high court can also go to the court of appeal for further scrutiny of such cases. Then we have a Supreme Court as well in the country, which is the apex or the highest court at the federal level as well. So therefore, this is a picture of a court. So this is a picture of a court, customary court of appeal in Edo State. This is a picture of a court here. So then let us now move to the functions of the judiciary. Functions of the judiciary. So when we talk about the functions of the judiciary, we have a number of functions that are performed by the judiciary or judicial arm of government in the country. So the first one is that the judiciary interprets the law. That is, the judiciary explains the content of the law before individuals, the plaintiff, and the defendants, or whoever wants to know more about the law that are there to witness the proceedings in the court. So therefore, it is the function of the judiciary to explain the content of the law to an individual in that before the court. Then the second one is that it settles disputes between any parties. When there is disagreement between two or more parties, or an individual and another individual, an organization and another organization. So such dispute or disagreements would be referred to the judiciary to adjudicate and explain what provisions of the constitution says concerning the case before each of the party, and try to declare the person who is guilty and who is not guilty not guilty. So eventually it is the judiciary that will be able to settle such disputes that cannot be resolved between two people or among two or more people in the society, where it cannot be resolved at the traditional level or at the family level. So such disagreements will be referred to the court or judiciary for proper pronouncement and settlement of such disagreements. Then the third one is that judicial officers advise on matters relating to constitutional preparation and amendment. Now what we are saying concerning this is that those who are members of the judiciary, that is the senior advocates in law making or the law among the lawyers, they will be there to actually guide people, the political leaders, in the course of preparing the constitution for the country. And in any case whereby such constitution requires any form of amendment, it is this judiciary that also see the way it could be done in a way to ensure effectiveness of such constitution after the amendment. Then the fourth one is that it determines whether a person or an organization or government is innocent or guilty. So when there are disputes or disagreements, it is the function of the judiciary to declare those who are innocent or guilty as guilty persons, especially when there are criminal cases and in a case where there are many innocent before the court. So at the end of the day, with the evidences presented before the court, so they'll be able to know those who are innocent and those who are guilty based on the investigation of the police officers that are in charge in charge of such cases. Then the fifth one here, which is it protects the individuals and group rights and liberty by ordering the release of any person detained unjustly. I recapitulate. It protects the individuals and group rights and liberty by ordering the release of any person detained unjustly. So when we said protection of individual rights, individually we have our fundamental human rights in the country, which has to be protected by the judiciary. For instance, when there is a criminal case and the police arrested a number of people and trying to investigate, such persons that are involved in the course of the investigation should not be delayed more than 24 hours. And if such happens, that is a kind of infringement on the individual right we are talking about, because that has gone against the provision of the law or the constitution for individual rights. And if there is any need for such, the police should refer the case to the court within the next 24 hours so that appropriate steps and actions could be taken. So if we have such a case where somebody's right is infringed upon, so it is the right of the judiciary to actually ensure the liberty of such persons to enjoy his freedom, so that such person will not be detained unnecessarily by the police officers. So that is the point number 5 on the functions of the judiciary. So before we now move to the next subtopic there, this is another picture of our court here. You can see here. So that will make us to be familiar with the court of law. And I know some of us have been to the different courts we have in our society. Then another thing we want to consider is the essential characteristics of the judiciary. So when we talk about essential characteristics of the judiciary, we are talking about some distinguished features of the judiciary, and such we make them to be well recognized as those who are worthy of preserving the individual rights and settling disputes in the country. So now, when we talk about the essential characteristics, we have about 5 of them here. So therefore, the first one here is that the judiciary should be free and impartial in judgment of any kind. That is one of the essential characteristics of the judiciary. Judiciary should be free and impartial in judgment of any kind. So when we say judiciary should be free, that is, the judiciary should be free from the intimidation of the executive arm of government or the legislature or any political members, so that they could be able to what? To carry out their function or to perform their duties according to the provisions of the constitution the way it's supposed to be done. So that at the end of the day there will be no impartiality in the course of administrative justice on any case before them. So they should be free from any form of intimidation from any political leader or any members of the executive or the judicial, the legislative arm of government in this respect. Then the second one here is that the judiciary is permanent while the legislature and executive come and go. Now when we say judiciary is permanent, what we are saying is that when we talk about the judiciary, we talk about the judges that are in the courts to administer justice here. They are on permanent employment. They are there to serve a number of years in the service. Unlike the legislative members or the executive members that will serve a term of 4 years or 8 years of 2 terms. No, theirs is not like that. They will be there as long as they are performing their duty the way it is supposed to be performed in the society until their retirement age. So they are there permanently, not tenoring as applicable to that of executive and executive. They will be there for as long as the number of years they are required to serve in the judicial arm of government. Then the third one is that it should be neutral in politics. When we say judiciary should be neutral in politics, what we are saying is that the judges, the lawyers, they should not be involved in the political party activities. They should not belong to any political parties, so that eventually when there is any case to be or disagreement to be settled, they will not be partial in the course of rendering their justice in that case. Then the fourth one there is that the judiciary reconciles disagreements between the other two arms of government whenever there is problem. You know, when we talk about disagreement or conflict, wherever we have human beings in operation, that is bound to happen. So when we talk about the executive and legislature, so it is sure that there will be disagreement between the two parties, one way or the other. So when such disagreement occurs, it is the judicial arm of government that settle or reconcile such disagreements between the two parties that are involved. And at the end of the day, they resort to the provisions of the Constitution in order to resolve such issues between the two parties. That is the legislature and the executive arm of government. Then the other one is which is the fifth one here, is the judiciary. That judiciary should be independent from the absolute control of either the executive or the legislature. So when we are talking about independence from the absolute control of either executive or the legislature, that is, we are expecting the judiciary to be in control of itself. What we are saying is that the judges, the courts should be in control of itself without the intervention of the executive or the legislature, since they are independent body on their own or arm of government on their own. So, and when this occurs, it brings about a true separation of power in the three arms of government, which will bring about proper administration and governance in the country. So therefore, this the internal courts, where we have where we have the judges, the lawyers, then we have the pressmen here as well. So here as well. Then let us now move to the independence of the judiciary. The independence of the judiciary. So when we say independence of judiciary, this is a subtopic again that is very important for us to understand in the course of our lesson for today. So when we say the independence of the judiciary, the meaning is just that the judiciary should be isolated from the control of the legislature or the executive arm of government or anybody, and that is telling us that the judges should have the full powers to try cases brought before them without fear or favour. So when we are saying that the judges should have the full powers to try cases brought before them without fear or favour, that means they should be able to enjoy certain degree of freedom to carry out their functions in the judiciary. So whereby we will not have any member of the executive or the legislature to influence their decision or to influence their functions in the course of administering justice in the country. So and when they are trying to do that, it should not be a case whereby they be afraid of a particular godfather or a particular political leader in the society or in favour of anybody, but it should be in accordance to the provision of the law and the ethic of the profession. And here we have the picture of the Chief Justice of Nigeria. This is Justice Ibrahim Tanko Muhammad. So he is the present Chief Justice of Nigeria. So now let us now move to how to really maintain judicial independence. How do we maintain the judicial independence? So if we are saying that judiciary should be independent, so there are ways we have to really ensure that, so that at the end of the day, nothing will be able to be an element that will be used as a kind of inducement or a kind of a source spot to actually make the judiciary to be independent at the end of the day. So number one here is that the judges should be appointed from proven members of the bar. When we say the judges should be appointed from the proven members of the bar, we are talking about the judges that have integrity, that maintain the good names, that have not been their image have not been tarnished by the public members, that have not received any form of bribery or not involved in any form of corruption in the course of carrying out their functions in the society. So when we have those judges with integrity in the bar, and we have them as our judges in the country, so we'll be able to have the true independence of the judicial system in the country. So the other one is that the judges should be immune from prosecution in the course of performing their duties. So when we say the judges should be immune, that is, they are to be protected in the course of carrying out their function and duties in the society, so that when they want to administer justice, so no form of threat anywhere to actually not make them to be able to actually pronounce those who are guilty of their offences at the end of the day. So they should be well protected, and the provisions of the law should also protect them as well, so that they be freed from any form of threats from any individuals in the society. So the third one here is that the judiciary should be well remunerated, and the payment should not subject to executive or legislative manipulation. Now when we talk of remuneration here of the judiciary, we are saying that judiciary should be well paid, so that there is no amount of money that could be brought to them to actually induce or to influence them to perform otherwise in the course of administering justice, that will be able to change their mind in the course of carrying out their functions in the society. So their salary, basic salaries and allowances and other fringe benefits must be what? Must be adequately paid and well paid as well, so that no amount of money can be used to buy them over any cases. Then the fourth one is that the judges must not belong to any political party in order to avoid party influence. So when we are talking about this, they should not be allowed at all to be a party member, because there is no how they will one way or the other favour the political party in which they belong to. But when they are not a member of any political party, they could be able to administer justice accordingly. Then the fifth one there is that judges must be provided with adequate security for their personal safety. So adequate security, that means they must ensure that policemen are there to protect them in the course of moving from one place to another, because the country we find ourselves today, people can do anything to ensure that the justice comes to their side, or the justice is not administered the way it is supposed to be administered in the country. So in order to ensure that, to ensure the safety of the justice, the security of the judges is also paramount at this junction. So these are the five ways we can maintain the judicial independence in the country. So we have evaluations here, so which you have to go through. The evaluation is here with the assignment, which you have to attempt as well. So we have talked about the meaning of judiciary. We have talked about the meaning of the judiciary here. We have talked about the functions of the judiciary, then the essential characteristics of the judiciary, then independence of judiciary, as well as how to maintain the judicial independence in the country. I hope with this we will be able to come to the end of the topic for today. So as we are still at home, I wish us safety at home. Thank you very much. God bless you.